Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner, and also a state attorney. What I'd like to talk about in this particular episode is the survivor's trust, the credit trust, and other trusts that happen and occur when you're married to someone and when one of the spouses dies. Okay, there's lots of different issues that happen in this particular case, and you have to be aware that the different trusts that occur upon the death of one of the spouses is important insofar as there's a lot of things that happen. And if you're going to create a trust and you're married, you need to be able to follow the necessary procedures once one of the spouses dies, or there could be very severe tax consequences, gift consequences. The subtrust might be deemed to be invalid because it wasn't properly funded. I mean, there's all kinds of stuff that ultimately could happen. So let's go over some of the terms. First would be the survivor's trust. The survivor's trust is also sometimes referred to as the A trust, meaning that sometimes you'll see, when you're creating a trust, you'll see the A/B trust. The A would be designated as to what the survivor gets, and the B, which we'll get into in a little bit, will be designated what goes into the deceased trust, spouse's trust. So I was once told a fairly humorous way of remembering which is which. The A is above ground, which means the surviving spouse, and the B is below ground, the one that's deceased. So that's how you can remember which part's A and which part's B. So what's included in the surviving trust? Well, that would be, remember, you have two people that are married, one dies, and one is the survivor. So the survivor gets normally certain property, which then immediately goes into the survivor's trust. So that would be the surviving spouse's separate property because the deceased spouse has no claim to that. It would be 1/2 of the surviving spouse's community property, and then anything else that might have been agreed upon, the residence, personal assets, jewelry, whatever they both agreed upon would go into the surviving spouse's trust. Okay. Now, the particular items that go into the surviving trust, that's all revocable. Okay, meaning that the survivor can keep it, sell it, bequeath it to somebody else, not bequeath it, whatever they want to do. It's completely revocable. So that in a nutshell, I mean, there's lots more obviously, but that in a nutshell would be the surviving spouse trust. Now, what about the disclaimer trust? Okay, a disclaimer trust would be one where the property would not normally go into the surviving trust, would normally go into the B or to the irrevocable trust to the person who has deceased, but that person has disclaimed any rights to that particular property. Okay, I mean, basically it's like saying, I don't care about that property. I don't want to have anything more to do with it. I don't care where it goes. Let the survivor have it. Okay, that's really what goes into a disclaimer's trust. So the disclaimer, what that person has disclaimed, that will also go into the survivor's trust. Now, we're going to do another video on other parts here, but that, in a nutshell, are the items that will go into the survivor trust, and it's not automatic. I mean, there's procedures that have to be done in order to make it go forward, but if they're properly done, then it's possible to successfully allocate the necessary items that goes into the survivor's trust. Okay, more in the coming videos.